We waited for it, and now it is settled. The Supreme Court denies to take up AB5. So what does that mean? Let's go into it. Hello, and welcome to Trucking Answers. I'm Mark, your supreme host. And AB5 has been on hold, okay? It's been on hold because it was pending a Supreme Court review. Hey, I forgot to put this in there, so hang on a minute. Let's get this in. You are going to see a lot of clickbait titles coming up here very soon from people who are just trying to get views. This is the end of trucking. It'll say the end of owner-operators, the end of the world. This is the end of the world, and we know it, all that kind of stuff. None of that is true, okay? None of that is true. So as we go through and look at what AB5 is and what it isn't, remember that simply to be independent, you actually have to be independent. Okay, we're going to go through the 3 points of it here. But many people who lease a truck especially are not independent. The company controls what you do. That means you are not independent. Also, if you are a 1099 driver, as they say, the company dispatches you, the company tells you where to fuel, you do not qualify under this regulation. And as I'll say again here, you are considered an employee unless the company proves otherwise. That is part of this as well. The simple way to get around this is to simply buy a truck yourself and get your own authority, and then a trucking company can give your trucking company freight to move. That's how you do it. Absent that, you've got a real issue. Back to your regularly scheduled programming already in progress. Now, AB5, as many of you know, has been the law in California, where people are independent contractors or not based on a number of factors, 3 factors. And so a lot of people who are independent are, of course, being hosed. Many people who lease trucks from their carrier are really employees because of all the control that the carrier exerts. There's 3 prongs to this law. Number 1, you have to be free of control and direction by your employer. Here in trucking, we would call that your carrier. They can't tell you where to go, what route to take, to wear a uniform, any of these kind of things. Buy insurance from them, make you buy insurance. They can only offer these things to you. And as we get into this, I should say this, that I'm not an attorney and this shouldn't be considered legal advice. If you'd like legal advice, go seek an attorney of your choice. The 3rd prong, which is also easier to make, is that you have to be engaged in a trade that is generally considered an independent trade. Like, this is a common thing that people do independently. The middle prong is the one that gets everybody. You have to be engaged in a trade that is outside the normal scope of business of the carrier in this case. So a motor carrier that hires you to move freight, well, that is their scope of business. A motor carrier could hire a plumber independently for a limited period of time and have them fix something at the place or whatever, but hiring a driver, not allowed in California, right? But this was put on hold. It went up into the courts and was put on hold. It went to the Supreme Court. Supreme Court just said, no, we're not going to look at it. That means the hold, maybe even today or in the very near future, will be released from it and it goes into effect. Now, I know Prime and Landstar had stopped taking people from California. New Jersey is looking into this law. Illinois is looking into it. New Jersey is way farther down the way, like closer to implementing it. Illinois is another one that's looking into it. And here's the thing. People say, oh, well, Mark, people should be independent. If you are an employee, you should be an employee. All this does for companies is put all the costs on the person. Like, here's the truck payment. You trick your own workman's comp. You don't get any insurance. You don't get any vacation or anything. And you generally make less than a company driver at a good company. So all these companies, especially ones in like the west suburbs of Chicago and that, they probably won't be going to California. And as these laws fall, and it changes in Illinois mainly, that'll end all these, all that kind of thing. And in California, another part of this is that you are automatically considered an employee unless proven otherwise. So the onus is on the business to prove that you are independent. You are automatically an employee right off the bat, and then The business has to say, no, this is why this person is independent. It doesn't work the other way around. Way too many people, especially California, at the ports, and plus a lot of these carriers that lease trucks, right? These people are employees. You should at least have more autonomy in your job than I do. I have an open fuel card, all right? If you are leasing a truck, buying the fuel, and they tell you where to fuel, you're an employee. Either way, that's the story right now. AB5 hold could be up by the time you watch this video. Possibly, maybe, we'll see. Thanks for watching, and we'll be back soon with another Trucking Answers.